Good morning, everybody, and welcome. Welcome to another edition of the New York City Hospitality Group's Reopening Webinar Series. We have a very special program here today on sort of the legal considerations when opening now that we're in phase 2. We have an esteemed panel that will sort of share sort of what's going on in their world from their perspective, from the legal perspective. And we have an operator that are going to be joining us. And I'm going to have Kate Edwards, who I have the honor of introducing, who's a member of the New York City Hospitality Group, who's also an author, an executive coach, and speaker, sort of introduce our panel. So thank you so much for being here. Kate?
Thanks so much, Derek. Glad to be with you and very happy to be part of this webinar. So today we're going to be talking about the legal implications of bringing your teams back. Everyone's excited to bring people back to work. And the thing is, we have to be aware of how do we do this? Are we rehiring people? Are we just onboarding them again? How does it all work? We want to have a dialogue about this, and we're going to be featuring our labor attorney, Adam Gross, our in-house HR expert, Leah Regal, and also someone who's a friend of a number of us, Katina Ruhumbika, who is the director of HR for Major Food Group. So I'd like to invite each of them to come into the conversation. You can all introduce yourselves briefly if you'd like to, and I think Leah, you have a great starting point for this conversation.
Great.
Oh, something I will invite too is ask questions, use the Q&A, and you can also use the group chat to ask questions. We'll be monitoring those, and we'll have time for Q&A at the end of the conversation. Thank you.
Great, thanks, Kate. Certainly excited to be here with colleagues, Adam, Katina, and we're just kicking it off. I mean, we're holding dialogues, obviously, with individuals, clients, our team, and some of the questions that come up. Well, I want to hire back all my managers, but just not the one that's pregnant. Okay, we got to talk about that. Well, I terminated everyone back in March, and I have a clean slate, so I'm just going to rehire the individuals that I like. Well, maybe not. Maybe if you want to hire Adam for the next 3 months to get you through some of those legal implications. So we're just going to kick it off and go through some of those scenarios in an interactive dialogue.
Okay. Okay, while Leah's getting the next slide up, I can introduce myself. So I'm Adam Gross. I am a member of the New York City Hospitality Group. I am a labor employment attorney. I work a lot with restaurants in New York City and outside, specifically on compliance issues and, in worst case scenarios, litigation, which hopefully none of you are going to experience in the aftermath of this pandemic. So one of the things that we wanted to do today was to highlight some of the areas that we think are particularly ripe for potential litigation. And that's not just us guessing at this point, because we are now far enough along in this that we can actually say definitively that we are starting to see some of these claims. So Leah mentioned a couple of scenarios a moment ago, and I will tell you that I have had 2 operators in the last week who have had nasty letters from a lawyer about these exact same issues. So specifically, one of the big things that I have been harping upon to restaurants is that you need to think about rehiring employees in the same way as you would think about making determinations as to who to terminate. And by that, I mean, there's a perception in, among some, maybe not among everybody, but among some, that if you laid off your staff, if you terminated your staff back in March at the beginning of the pandemic, that you now have a clean slate to determine who to bring back, and no one has any rights or any claims because they're not your employees anymore, and so therefore you can do as you will with impunity. And that is just very much not the case, because remember that our laws in New York City, New York State, and the federal laws protect employees in the hiring process from any sort of discriminatory practices in the hiring process. And so if you had 25 employees previously in the beginning of March, and now you're only going to bring back in the immediate future, 15 of those employees, the best practice is to make those decisions based on a set of objective criteria, so that in the event that one of those 10 employees who is not hired back says, hey, how come you brought back these 3 bussers and not me? I think it must be because of my age or my disability or whatever the protected category might be. You want to be in the best possible position to say, to explain using an objective criteria why that decision was made and why it was that you hired those other people and not this person. And that puts you in the best position to defend against the claim. And so within the, and Katina and Leah can jump in at any point, but within the restaurant industry, oftentimes I find that the best, most clean-cut objective criteria is tenure, because unlike certain other industries where you might have detailed objective performance metrics that you can legitimately use to filter between employees in the same position, we don't normally have that in the restaurant world. And so tenure is objective. Hopefully tenure covers the employees that you would want to bring back. And so what I have been discussing with restaurants is figure out, and I think Katina can talk to their experience, but I think that this is what they're also doing. Figure out how many employees you need in each role. How many people do you need in the back of the house? How many front of house staff do you need? How many bartenders do you need? Whatever the category is, and then try to figure out the objective criteria to maybe presumably tenure based to figure out which employees you're going to bring back.
Yeah, sorry, Adam, and I'll jump in. And just to add to that too as well, tenure is the most objective approach, but I also understand it being on this side, right, from the HR end, and working close with operators who need to want to bring back the best people, right, the best employees. I think that would apply in any industry, right? Use this opportunity to bring back, what we call your A players, right? The utility players that can do a lot. However, just keep in mind that also is feasible. It's not impossible. However, you must be able to clearly demonstrate those performance metrics that you use to determine what makes someone an A player, right, from a B player. And I would say, a lot of us, we don't have those performance metrics clearly outlined to clearly demonstrate that too as well. So whatever those metrics that you're using, making sure that they're fair and equitable, non-discriminatory across the board, and you can clearly demonstrate that your hiring practices are fair across the board to all individuals.
And I think that that's 100%. I mean, I think that that's 100% correct. And I would just add to that that may legitimately frame an operator's decision as to how many. If you have 3 superstar bussers, you might decide that you need 3 bussers as opposed to 2, because you're going to make those decisions based on obviously who your best performing employees are. So you want to try to frame it in an objective way, but obviously, you're running a business, as Katina said, you want your best people back. And so you try to do it in a way that accomplishes that.
Right, and just to add to it, I mean, I would encourage operators, HR professionals to print the list of employees in department and go through the exercise. Look at the names, have a reason, have that framework laid out as you've gone through it. So that can only support you later on if you were challenged, but you went through the exercise, you have a clear methodology of whom you're bringing back, why you're bringing back based on seniority, continuity, work performance, etc. But you really shouldn't go from just your memory, right? Oh, this person was good. I think this person was hired here. Go through it. Print date of hires. If they're adjusted date of hires, the exercise is definitely something that you should be participating in. I think we can move to the next slide.
I actually have a Q&A question here from someone on this topic. This is from Nandu Awatramani. Can you and how can you hire for character first before performance and tenure? Does that even come into it or does it not?
So I can answer Nandu's question just from a legal perspective, and then Katina or Leah can jump in from a more an operator standpoint. From a legal perspective, Nandu, I would say that that's difficult because how are you quantifying character? It's sort of an intangible quality, and it's obviously an important one. No one is going to argue otherwise. But what I would hope is that if someone didn't have the type of character that you wanted in your restaurant, that's been documented in some sort of way throughout their tenure in the form of performance, either formal performance reviews or disciplinary write-ups or whatever the case might be. But you would hope that that's made its way to some sort of documentation, so you have some legitimate, something legitimate on paper to point to as to why maybe that person was not brought back and somebody else was.
Yeah, I think Adam answered that the same way I would.
Same.
Yeah, I'm not sure how you can actually measure character, right? In a way that's fair, in a way, you know, there's sometimes character is determined by cultural nuances, as and working in New York City where there's so many different cultures. That's the first thing I think of, right? There's different metrics for how I see character, how someone else sees character too as well. And has that been clearly communicated company-wide or organization-wide? As you know, I would say even pre-COVID, is that a widely known standard within your organization, and making sure that it's actually a fair standard too as well. So I think that would be a difficult one to demonstrate and actually from a legality standpoint stand by.
In 100% agreement with those two thoughts for sure. Revisiting Warren just briefly,
Okay.
This was discussed in great detail, March through April, but just to touch upon it, Adam.
Okay, so we're not going to spend much time on Warren. I just want to remind everyone that presumably if you have enough, if you are a restaurant that has enough employees such that you're subject to the New York's Warren law, you probably or hopefully went through an analysis as to whether you should send out notices back in March when you were forced to close. The one point I want to make is that there was a thought process back in March that we don't need to send out notices because the Warren Act does not apply if the closure is for less than 6 months. And that's true with a caveat. And so the only thing I want to point out is that you can have a Warren covered event if you hit the number of employee terminations, the threshold, like at least 25 employees, and they are out of work for more than 6 months. So if you have a larger venue and you had 100 employees, let's say 100 full-time employees at the time that you closed, and now you're thinking about bringing people back and you're realizing, okay, you're going to be you're hopeful to be reopening within 6 months, but you're only planning to bring back 40 employees in the first instance, and you're only offering 40 people's jobs. And so if that's the case, you know, it's still very possible that even if you're open, you might not be offering enough people jobs back within that 6 month period to be compliant under Warren. And so I just wanted to bring that to people's attention such that if you haven't sent out the notices and you think you might be covered, you might want to talk with your with counsel about whether it makes sense to think about doing so now.
Onboarding requirements. On the top of every operator's mind probably right now. Katina, if you want to kind of jump in, see what your group's doing.
Yeah, so I would just say just a general practice. It makes sense to have a new onboarding checklist, right? Depending on when you're bringing, depending on when you're rehiring, right? Your employees. So making sure you have an onboarding checklist. If there are any new additions or any changes to the handbook, I think this would be a great time for employees to sign off on that, or just a pressure on that. Any new safety policies relating, you know, addressing COVID, what's happening. Any, you know, there's a new hand washing technique. If you are implementing temperature checks, making sure employees are knowledgeable on that and they understand why you're doing it, and you know, making sure they've also signed off that I think is incredibly important. Wage notices, right? Those are super important. You know, if you've terminated employees and you are rehiring them, even if you're rehiring them at the exact same pay rate, they need a new wage notice. So making sure you absolutely have that. That's the one thing that I would say, I mean, all of these things you should do, but the one thing that, you know, you cannot, it's one thing that you absolutely must do, I would say, is definitely make sure you have issues with wage notices employees have signed off. I think with I-9s, you have, let's say, Adam, with 6 months?
Yes.
You have 6 months, so you don't have to re-verify an I-9 or take a new I-9 unless maybe it gets expired, et cetera. But if it's within the 6 months between, say, if you laid off, terminated between March and then hiring up to September, end of September, you're in the clear. But I would still say making sure that you have a checklist for every employee is consistent and you're demonstrating for each employee this is exactly what we're consistent across the board.
So Katina just, that's why I love working with Katina so much, because she said exactly what I would have said. But I think that the important thing to emphasize is that even though in March, when a lot of restaurants closed and they had every intention of reopening and rehiring all of their employees, and you're bringing back a lot, or maybe exclusively people who were working for you before you closed, so it doesn't feel in some ways as you're bringing on new employees, from a legal perspective, you terminated people. And it's important that you, not that you wanted to terminate people, but we don't want people claiming that they were actually your employee during the period that they were terminated, and they weren't. And so these are, from a legal perspective, new employees. So anything, with few exceptions. So anything like the I-9 that Katina mentioned, but anything that you would issue to a new employee, wage notice form being of paramount importance because there's an actual potential financial penalty for not doing so, you should be giving to people when you bring them back. And as Katina said, it's a perfect time to also implement new policies and to provide them to your employees on the way back in, which everybody is going to need at least some new policies, whether they're reduced, whether they're put permanently in the handbook or they're standalone. I mean, obviously, restaurants are going to be required to have all sorts of new safety procedures in place. That was a foreign concept a couple of months ago.
Right. I mean, I think more information, if it's correct information, you feel confident with your safety guidelines, et cetera, it puts more ease with the employee. If they're feeling cautious of coming back in the workplace, you can have a clear outline that the employee is reviewing, understanding, and agreeing that they're going to be participating in once they're back in the workplace. So I think just from a human standpoint, managers, employees, et cetera, are coming back in and saying, okay, the company's doing this, they're actually doing it in the workspace as well. They're not just writing it. I feel more confident coming back into the workplace. And just to touch upon, oh, sorry, Adam.
No, go ahead, Leah.
No, to touch upon the benefits waiting periods, quick advice on that is just to be ensure that you're in touch with either carrier directly or the broker to understand what flexibility you have. The stances that I have seen thus far is just if you're an absolute new employee, you haven't been working with the organization previously, you are abiding by the waiting period. And then if you are a rehire, there's potentially two options for your organization is to, again, abide by the waiting period that was in place prior, or carriers are being more relaxed and you can come on first of the month following the date of hire, but just ensure, again, the overarching theme of this dialogue is to be consistent. So you can't pick and choose. Well, this person, I don't know if they're going to make it, so I'm going to have them wait out first of the month following 60. Not quite. Consistent.
One thing I just wanted to mention that Leah, something you said made me think about. A lot of clients are asking, and Leah mentioned trying to make your employees feel comfortable when they're returning and let them have confidence that you're doing things the right way and that you're committed to keeping them and the restaurant's guests safe. A lot of clients in many industries, not just the hospitality industry, are asking about having employees, when they return to work, sign waivers of liability in the event that they contract the virus, presumably at work. There could be different opinions on this, but I will just give you my opinion. Number one, if you have an employee who is, who clearly gets the virus, who you're able to demonstrate gets the virus from work, that's going to be a workers' comp claim, and you can't waive your right to future workers' comp claims. So I don't think that the waiver from that perspective really provides any protection. I don't think it would be an enforceable waiver. And I think that it sends, we have a slide in a few minutes that sort of talks about terms that send the wrong message. I think providing employees when they're coming back into the workplace with a waiver of liability is a somewhat crass thing to do. And I think And I say this because I've actually spoken to a couple of businesses that have tried this and have received a lot of pushback. I think that it could send the wrong message to employees and upset employees and have the opposite effect, especially when I don't think there's much legal benefit, if any.
Okay. Moving on to what to pay employees. Definitely going hand in hand with that wage acknowledgement we just spoke about.
Yeah, so first things first, whatever you decide you're going to pay your employees, as Katina said, you're going to give them a wage notice form that accurately reflects what they're going to be paid. And to be clear, wage notice forms are required to be given whenever someone's hired. And then also you want to give new wage notice forms when pay is changed. And so even if you had somebody who was making $25 an hour and you're going to bring them back at $20 an hour, but the understanding is that after a couple of weeks and once the restaurant ramps up, they're going to go back to their previous rate. You're going to give them the $20 an hour wage notice form when they're hired, and then you're going to give them a new form that says $25 an hour when they move to $25 an hour. So we want to make sure that at all times people are working people are working under a rate that's accurately reflected in their current wage notice form. We have a note here about appreciation pay for hazard pay. A lot of restaurants have been giving people, especially given the amount that people are receiving on unemployment or potentially receiving on unemployment right now, they're incentivizing people to come back by potentially giving them extra than more money than what they were making previously. For the same reason that I don't like the waivers, I don't like the term hazard pay, because we don't want to make it seem like coming to work is a hazard. In fact, what we're doing is we're keeping our workspace as safe as we possibly can. We're following the CDC and all local health department guidance. We are taking extra precautions with respect to social distancing and PPE, et cetera. And so we want to convey, because it's the truth, that coming to work is a safe, it's a safe environment to come to work. And calling something hazard pay sort of contradicts that notion. So you certainly can pay people additional to what they were working, what they were being paid previously, but let's not call it hazard pay. Some people, a lot of restaurants have been having issues, and Katina and Leah jump in. But a lot of people are having issues with getting people to agree to come back to work because they don't want to forego the amount of money that they're currently receiving on unemployment. And most people are aware that the federal government, as part of the CARES Act, provided for a $600 weekly supplement to unemployment, such that in New York, if someone qualifies for full unemployment, they're making, on a prorated basis right now, above $57,000 a year in unemployment. And so, for example, if you had, any employee, whether back of house or front of house, especially since tips are lower a lot of the time now, it's going to be very hard to pay them at their regular rate anything that would get them close to that level. And so one of the things that some restaurants have been taking advantage of is having people come back on part-time basis so that they can work fewer, a couple of shifts a week, fewer than 20 hours, and that still enables them to collect potential, likely the $600 supplement, because what the CARES Act said is that so long as you are eligible to receive unemployment, whether partial benefits or full benefits, so even if you're getting, $50 in New York State unemployment, you're still entitled to the full $600 under the CARES Act. And that expires at the end of July as of right now. And so we expect that starting in August, it may be much easier to convince people to return to the workplace.
Yeah, and even as you said, bringing people back and want to pay people, I think there's obviously the business standpoint, right? That you are ready for business or partially ready for business and you want to bring back your staff. And the second piece, right? Thinking through, how does this impact, what's the financial impact for this individual, right? Is it beneficial for them, honestly, to stay in employment, right? Or do we want, is it beneficial to stay in unemployment because we can't guarantee their hours? So what I've seen some of my peers are doing is, some organizations are guaranteeing hours. That is a way to entice the individual, right, to come back to work and being able to say, hey, you know what, we feel strongly about our footing and where we are right now. So we understand that being unemployment is a benefit to you. However, here's a greater benefit. We're going to give you full time too as well.
Yeah, I mean, and I think, I mean, a lot of operators that I'm speaking to, this is where most of the creativity is coming in, because we're following the guidelines, we're going through a methodology, we're going through seniority. Okay, well, we have 17 servers, we're down to number 10 that doesn't want to come back, right? So it's sort of, okay, how do we offset that? Maybe we can, the partial unemployment seems to be very popular right now, just offering, keeping an employee under the 405 wages in a week and working less than 4 shifts a week, and being flexible with individuals and what makes most sense for the organization. A lot of restaurants right now are just opening for that dining space or the evening dining space. So if they're just working a few hours in the evening, how can they continue to collect partial unemployment, et cetera? But also the reality at some point is we have an operation to run. We need bodies to fill these positions. We need people back, right? So here's what we're offering. And listen, it may not be ideal, and it may be the hard conversations. It may be line cooks that were making 18 that are now making 15. And we get that. But that's the reality of it. And we need bodies back. And this is what we have to offer at the moment, right? Say senior leadership is continuously looking at all business levels. But this is the job that we have right now.
The other thing that I wanted to mention, and it talks about it on the bottom bullets on the slide, is restaurants are used to, most restaurants in New York City, for their front of house staff are utilizing a tip credit, meaning that they're taking the minimum wage in New York City for large restaurants, you know, of 11 or more employees is $15 an hour. And so front of house staff, we're used to paying them effectively $10 an hour, because you're entitled to, if you meet various preconditions, you're entitled to take a $5 tip credit. One of those preconditions, and keeping this high level so we don't go into the weeds here, but one of those conditions revolves around what's called the 80-20 rule. And the 80-20 rule says that if you're going to take a tip credit as a restaurant, you have to ensure that the individuals who you're applying that credit to are not spending more than 20% or 2 hours, whichever is less, of their shift on non-tip generating work. And so one thing that we have seen from operators is that because of the unusual nature of the restaurant operation now, and it's not, you don't have the same amount, you don't have the same number of tables, you don't necessarily have the ability to have front of house staff do nothing other than, you know, service customers. You might need them to be more, you might need them to be involved in packaging deliveries. You might need them to be involved in setting up stations, whatever the case might be. And so it's important that you recognize that if that is going to be the case, and you're going to have people doing various different jobs, to pay the full minimum wage of the $15 an hour and not take the tip credit. Because the biggest source of litigation in this industry revolves around restaurants taking the tip credit when some individual alleges that they were not able to do so. And the penalty for that is paying for every hour worked during the period of any sort of infraction, is paying the difference between the $10 and the $15. And it's a claim that lends itself quite easily to multiple people bringing as part of the same case, because generally the policy is uniform across the board.
And that really goes hand in hand with our next dialogue here as it relates to the misclassification of exempt, non-exempt employees. I just held this conversation with a client the other day. They went through the methodology and they hired back just managers. Okay, we positioned it. We can't just hire back all managers in their same roles because the exemption guidelines pertain to this conversation. So we classified then, and the reality of it again was that now managers that were floor managers are now supporting in takeout and delivery. So they're baggers, they're supporting in different areas, and they're not managers. So we had to retrain our brains and stop calling them managers and calling them their hourly employees now, whether for the time being or whatever the situation is. But now it's different, and the conversation sort of happened, and then in a couple weeks we revisited the conversation because we realized tips weren't being distributed, and they said, well, we're not distributing tips because they're all managers. Again, retraining our brain and saying, no, now they're classified as hourly employees. They're no longer managing, they're not management team right now. So again, Adam, Katina can speak to experiences with this, but this is super important when bringing back employees to ensure that they're being properly classified.
So I just want to take a step back and just be basic about what qualifies as an exempt employee. And so, there's often some confusion about this. So most operators know in New York that there's a salary threshold, so that if you're going to classify a manager as exempt, you have to, black letter, no discretion, have to pay them on a salary basis of at least $58,500 a year. So that's number one. But there's often a misconception that as long as you pay the $58,500, then you can do whatever you can have them do whatever you want, and there's no issue. And the importance of the exemption is that you're not going to be paying overtime. And so these exemptions are fundamentally being exempt from the overtime requirements under New York and federal law. And so if you don't qualify for the exemption, then you have to track the employee's hours just like you would a regular non-exempt employee. And if they work more than 40 hours in a week, you would have to pay premium, of time and a half for those hours over 40. And so the second component to the test beyond the $58,500 salary threshold is the duties that the individual is actually performing. And the title is largely irrelevant. So it doesn't matter what someone's title is. You could call someone the GM. If they're spending their time, waiting on tables and not actually doing any managing, that person is not a manager. And so you have to make sure that an individual who you're classifying as a manager actually has people or a department to manage that have, enough people in it such that, you have to be managing at all times at least 2 full-time, equivalent employees. And so what we've seen is that a lot of restaurants had a handful of managers, and that those might be their best employees, and maybe they've been with them the longest because they worked their way up from server or bartender to manager, and they want to bring those employees back first. And that's fine. But if you want to bring those employees back first and you only have 6 employees, 4 of them can't be managers. The math just doesn't work. And so exactly as Leah said, you want to make sure that you want to re-examine your exemptions to your classification of employees to make sure that if you're classifying someone as a manager, that they're actually performing managerial work, which is not to say that they can't occasionally work alongside some of the people that they're supervising, but are they involved still? Are they doing scheduling? Are they doing hiring, firing? How many people are they actually managing? What's their primary duty? Is it standing out, at the window to, pass people their food, or is it actually managing staff? And if you've made the determination that they're not managers, then we don't want to call them managers. We're going to pay them an hourly rate, and we're going to call them, what we call other employees. Because we don't want confusion among staff, especially, Leah mentioned, especially we can talk about tipping as a separate issue, but especially if they're going to be getting anywhere near a tip, which is fraught with issues, even having previous managers involved in tips, I think can send red flags up in an employee's head. But if you're going to allow them anywhere near a tip, you don't want there to be any ambiguity at all that they are managers. And so it has to be very clear to them, because we don't want customer issue between the 2 employees. You're a former manager saying, well, mediating the situation because I'm the manager. It has to be clear to everybody in the restaurant that they're no longer a manager.
Yep, I think you summed it up pretty well. I mean, this is a topic that we can spend a whole nother webinar on.
Certainly.
Yep.
And just as we're talking about tips, just to make a quick note, just to ensure that if you're preparing a temporary tip pool policy, that's okay. Just have it, just document it, and make sure everyone's aware of it, because positions are changing, right? Some there's cashiers, there's baggers, there's roles that not necessarily every restaurant had before, and that's okay. Organically go with the change and just just outline it so everyone is clear and they're aware of it.
And Katina and I have talked about this separately, but a lot of tipping, this pandemic has raised a lot of interesting questions with respect to tips, because there are we know in the restaurant industry that the tips are supposed to go to those who provide the service. But we're now experiencing more situations than ever where there's really no one who's providing the service, perhaps.
Or,
you know,
or the hourly employees, sorry, Adam, the hourly employees that you do have working are all back of house employees, right? So you may be in a situation where you have managers, right? And then you have hourly staff that are back of house, and it's fine to distribute the tips to those back of house hourly employees.
Right, so you always have to be making an assessment. Well, who's actually entitled to the tip? And if there's no one who's entitled to the tip, then what do you do with the money? And so people have come up with creative solutions to as Katina just sort of referenced. But these are unusual situations that didn't really exist before, because you would never have had a scenario where your only quote unquote front of house person was a manager, right? So definitely things to think about as you go through the reopening process.
This is on top of everyone's mind as well. First Coronavirus Response Act, also known FFCRA, as everyone's saying it. Adam, do you want to speak to this as well?
Yeah, just briefly. I think everyone knows that the federal government passed this emergency act that applies through the end of the year. New York State, we already had in New York City sick leave. New York State passed a quarantine, pay for quarantine leave, and expanded sick leave across the state. One thing, so the gist is that employees, there's no waiting period for eligibility for emergency paid sick leave under the FFCRA. So one thing that unfortunately is a reality that everyone needs to prepare themselves for, the possibility that you could hire somebody back. Someone could have worked a week, 3 days, a day. Maybe someone doesn't even make it into work on day one because they are sick themselves, someone in their household is sick. There's a qualifying reason for them to use emergency paid sick leave under the FFCRA. And again, there's no waiting period. So I think that, you know, those people are eligible for the sick pay. And so it would be, I mean, thankfully, New York seems to be, you know, trending in a very positive direction. And we hope that these instances are fewer and further between. But I will tell you, just in this week alone, I've talked to 10 clients who have had positive cases of people in the workplace. And so everyone should be aware that this is money or these sick days are going to be a reality, and that people are going to be entitled to them. And that once you tell somebody that once you rehire somebody and someone is hired, you know, if they get sick and they qualify for leave for pay under the FFCRA, you are going to be on the hook for paying them.
And also just as a reminder that we have a legal obligation to make sure we notify our employees, especially when they're rehires, of this notice as well. So making sure that whether you have added as an addendum to your handbook, it's posted in break room, in the restaurant, but we have a legal obligation to make sure that our employees are notified of this. Or else you run the risk of an employee, let's say, coming in contact or being around someone or even being sick, but because now they have committed to returning to work, guess what? And they think they don't have any time off, eligible paid, they're not coming into work sick. So it's important that your employees are aware of this leave.
Absolutely.
Right. And this topic goes right into our next slide, is continuing the dialogue. But I mean, a lot of these conversations we could spend hours on. But my biggest takeaway is when I'm speaking with clients is just to ensure that the communication is there, it's open, and it's transparent between managers, senior leadership, your human resources team. You just have to know what's going on. And what I mean by that is just holding the dialogue, right? Someone was sick, someone had a temperature, someone visited a family member that had COVID. Someone went to Florida, came back, and there was a 14-day mandatory now quarantine regulation. There's so many nuances of it. You just have to be aware of it and talk about it. It usually is going to be handled on a case-by-case scenario, just because there's different stipulations and regulations behind the FFCRA, right? Sometimes it's clear cut with those 6 different reasons, but you just have to talk about it, and you have to be aware of it, because you don't want to get trapped or pigeonholed where you didn't know, you should have offered. They had the 80 hours of FFCRA, but we didn't provide it. So I just encourage your management team to be aware of it and to talk about it, because a lot of just questions are coming up, right? I had an email the other day. I was like, well, can I send someone home that has a fever? We're still operating, right? You can still manage, right? Yes, you can. Let's talk about it. What does that mean for everyone else?
By the way, that I've had clients ask that too, and the answer to that question was always yes. You didn't need a pandemic to be able to send someone home with a fever. No one wants someone with a fever in your workspace, no matter what your workspace is.
Right. Or it's just can we mandate everyone to go get a test? No, you can certainly encourage and et cetera, and have I have a client that's saying if you want to go get tested, you carve out time during the day, speak to a manager about it, we'll pay for the time. There's a litany of different scenarios, but I just encourage to be open and ensure everyone's on the same page within the organization.
One thing and I'll just talk about it from a legal perspective, and then Katina and Leah, you guys can jump in from an HR perspective, but we talk here about PTO, and one thing that, Katina talked about, when you're bringing employees back, you're going to give them the new policies and the handbook and as part of the onboarding. One thing that everyone should be looking at is, to the extent that you have a PTO policy beyond sick time, as to whether you had a policy of paying people out for it, at the end of the year if it was not used, because they may not be able to use their PTO this year, whether you want to institute a temporary blackout of use of PTO days, because you already, businesses might already be stretched thin in terms of bodies, because people could be out involuntarily due to quarantining or whatever the other reasons might be. And so you might not, unfortunately, have the flexibility to allow people to take PTO. And so I think that is one particular policy that, as you're thinking about your policies and thinking about onboarding people and reopening, that you might want to look at to ensure that it is going to work for your business, at least in the short term.
Yeah, and I think that's the one question that I'm seeing a lot, just as I talk to my peers, is, hey, as they are reinstating employees, the question is, well, do I now get to use my PTO? So, as you start to embark on the journey of hiring, to Adam's point, making sure that you're having a dialogue internally first to address these things, because we know it's a benefit that employees expect, that they have earned. It's outstanding, especially if you furlough employees, now you're bringing them back, right? They want this benefit. So what's the fair way, the best way to where, right, it doesn't seem punitive to the employee, but also you're still also giving them a benefit as well.
Right. I think we're just going to head into our last slide here before we take on some questions. But we could spend so much time on all of these topics, but I think it's good to just get your gears going in the sense of everything that you need to be thinking about as an operator, as an HR professional, reopening here. So you go through your methodology of just rehiring people. Now you're in a position, in a space to, okay, what does that look like actually bringing employees back into the space? And just the statement of conduct a risk assessment, right? If you take a walk of your restaurant and think, okay, the flow of the bar, the flow of employees coming in, the flow of packages. If it's when we finally get to the next phase, if customers can come into the work, what does that all really look like? And this is just a quick snapshot of hopefully another segment that we have on this, but just ensuring that you are abiding by all of the state and local federal guidelines that are out there right now. I mean, Adam, we were talking before this, Adam just made a really good point if you want to talk to it, just regarding the posted safety plan.
Yeah, I just think to Leah's point that this is not just a good practice, this is a required practice, but this is what New York State is saying you have to do to reopen. And there's a very detailed process where you have to have a plan, you have to post a plan, you have to identify people who are going to be responsible for implementing each part of the plan. You have to have people attest to the fact that the plan is being followed. And we are starting to see, I'm starting to have clients who have had inquiries from the health department because employees are calling the health department and saying, I don't think my employer is following, required protocols. And what Governor Cuomo said on Friday and issued an executive order to that effect is that if the health department comes and it turns out that you've reopened and you have not followed the steps that are required for reopening in terms of the procedure laid out and you don't have your plan posted, et cetera, they're going to temporarily remove your liquor license and they're going to shut you down. So the stakes here are high, and it's not going to be just because of, or it's not likely to be just because of a random audit. It's going to be because an employee actually complained. And so there's a real tangible risk here to not following the required procedures, especially in this industry where the liquor license is, necessary in a lot of ways to operate and to make money. This is a crucial aspect about thinking about reopening.
So I think at this time I'll stop sharing, and hopefully we can get into a few. I see there's a few questions that have come through.
Yeah, we have quite a few actually. I'm just going to start with one that came in just one moment ago. Let me just find that guy. So there was a question about tests. So Jessica Che just said she understood that it was mandated by the state that all employees must get tested every 14 days. So let's just debunk this myth or uphold this myth. Which is it? Are you required for your employees to get tested every 14 days or not?
No, certainly no requirement to get your employees tested every 14 days. But just to be clear, you can require employees to be tested. That's something that the EEOC said you can do. In New York, part of the, and I don't have them in front of me, but part of the reopening procedures is that if you have a presumptive positive, there's all sorts of, there's guidelines as to when a person is allowed to be back into the workplace. And you are directed in New York as part of your plan to put together to have information, to provide information as to where the testing sites are that people can go to get tested. And when you have a presumptive positive, meaning someone fails your daily screening, you provide people on a daily basis, have you had any of these symptoms in the last, whatever the case might be. And if they can't say yes to or no, whatever the right answer is to all of those questions, then you're going to send them home. And you do encourage them to go get tested, and you're not going to let them back in until either they can produce a negative test or they've waited out of, they've had, I think it's got to be 10 days since the onset of the symptoms.
Right, and 3 days without any fever reducing medication.
Right.
So the direct answer is it's not a requirement for your employees to be tested every 14 days.
Terrific. That's great. Thank you, everybody. We had a couple questions coming around part-time employment. So one is about, in other markets, this is from Chandra Geis. In other markets, there's a restriction on how many hours you can work per day to qualify that person as part-time employment. But is that a thing here? So if somebody could work a 12-hour day and be unemployed or be part-time, or is it better that they work, no more than 4 hours a day for 5 days a week? What are there rules or regulations around part-time employment?
There are. You want me? I mean, I can answer that. So in New York, they've defined partial, and if I'm misspeaking, Katina or Leah, correct me, but they've defined partial unemployment as working no more than 4 days in a week and no more than, I think it's 20 hours. So I don't think, so in New York, you could have someone who worked, you know, one day in a week and happen to work 12 hours and still qualify for partial unemployment.
Yep.
And then another one, this came in right at the beginning from Heather O'Neill. What if you have a former employee that has another part-time job that is a high risk for COVID? We're concerned that this will increase risk for the other staff, but we don't want to penalize this person for their other part-time job. Any ideas of how to handle that scenario?
Adam, that sounds like a
Yeah,
legal.
well, as I was going to say, now where's everyone else on this one?
That's a tough one. I don't want to penalize this individual. I think we're all at risk, right, when we're outside in activities that we're doing. So I think, you know, making sure that this individual, you know, I'm sure, first of all, commend them for coming forward, you know, and saying, hey, you know, I work, you know, maybe they're a nurse, right? Or we wouldn't want to penalize someone that works in the medical field because they're taking care of others at all whatsoever. However, just making sure that, you know, when you are rehiring, that they're adhering to the same safety measures as everyone else.
And just to go along with that, and maybe this helps some, maybe it doesn't, but that's why, you know, New York requires you to do this, but that's why it's so important that you're going to have daily screening and certification, so that, you know, what we're recommending to clients is that every single day when employees come to work, before they can get through the doors, they have to fill out a sheet that requires them to answer the questions. You can decide, you know, whether you want to take temperature on premises or have people do it before they get there, but you want to make sure that you are checking for symptoms and everyone, you know, employees' health on a daily basis. And don't just leave it up to the employee and to, you know, to trust people. You want to make sure that you have a more in-depth screening process so that you can keep everyone safe.
Exactly.
Right. Sure. So this question came in right at the beginning of the webinar from Keith Francis. What type of accommodations do you have to make for an employee who doesn't want to work due to living with or caring for at-risk family members?
I think Adam, you want to start off with that one?
Yeah, so this is a tricky, I mean, it's a very common question. It's a tricky one. And I'm honestly not sure that there's a definitive answer to this yet. I mean, these laws are still, everything is still so new. What I would say to that is that that is definitely going to be a question that is tested in litigation. There's no question in my mind about it, because I think that there's enough gray area about what is required. Now, everyone in New York, if you're operating in New York, you're subject to the if you're operating in New York City, you're subject to the New York City human rights law, the New York State human rights law, and obviously federal law. And under each of those laws, there's an obligation to provide reasonable accommodations to individuals with disabilities. In the case of someone's own pre-existing condition that might exacerbate their susceptibility to catching the virus, or that might exacerbate the symptoms if they do get the virus, that might be, I think that is something, definitively is something that you would have to try to make a reasonable accommodation for under those laws. This is different, because this is asking for an accommodation as a result of someone else's potential medical issue. And it's not, I would tread I'm more conservative by nature, and I would probably, and I would recommend trying to accommodate to whatever extent possible. But I don't think it's as clear-cut of an issue. You know, I don't think it's a clear answer to that question at this point.
Got it. We had a couple questions also prior to this. And one of you actually answered this one. So how about this one? How to best address those who've gotten used to working from home and are now refusing to return to the office at work? So this is from a director of HR, Angela Wang. So how can you navigate that conversation? Katina, you seem to have some insights there.
Yeah, you know, I would say, obviously, you know, engage every conversation with empathy, right? Mm-hmm. So when someone's refusing to, let's say, go back to, you know, pre-COVID work conditions, the first thing I would do is ask why. You know, what's happening behind the scene? Refusing is a very strong word, right? Asking why, try to understand. They could have a valid, legitimate reason as to why, you know, this, you know, returning back into the office doesn't work for them. There's so much trauma, right, associated with what's happened in the world, not just with COVID, but, you know, with the protests that we're seeing, you know, so there's so much that's happening that people have had to, they're carrying that burden. People have been cooped up in their homes. So, you know, asking this individual, you know, help me understand what's happening and how and what we can do. But also being very clear and saying, you know what, we're now starting to operate as normal and we're asking all individuals to return back to work. But I don't think there's a clear cut and dry policy. I think being able to address every individual is important. But the main thing is also making sure you are consistent in how you're addressing it too. And you're treating all individuals the exact same way, all employees the exact same way. So if you are going to make an accommodation for this one employee who, let's say, you know, is a bit hesitant to returning, if you have another employee that comes with the same reservations, making sure you're also giving them a fair hearing and understanding as to, you know, your reason for wanting them to come back to work and maybe your reason for denying their request to stay from home as well. So, you know, Adam said earlier, all these things are still fairly new. There's not a lot of case law around it. But I would say treating, you know, going to every situation, you know, with some humanity and empathy and understanding for your employees and being able to, as much as possible, work with them and easing them back into the workplace. I think for anyone, it'd be difficult from going through, you know, March, you know, everything shut off, and then it's a hard date of, okay, now you're asking you to come back to work next week. There could be child care issues. There could be transportation issues. So many factors as to why someone would be hesitant to return to work.
And something that Katina just said made me think about something else that I just wanted to mention briefly. I mentioned before that, you know, and Katina said it exactly as I would have, but you want to make sure you understand the reason why they say that they can't come back to work. And one of the things that we're seeing that might require an accommodation is even if someone does not have a pre-existing condition, or even if somebody, you know, does not have any sort of medical reason that they might be more susceptible to catch the virus, what we are seeing a lot of that also could require, you know, because of everything that's going on in the world, people are experiencing anxiety, right? And they're having their own mental health issues. And that requires, you know, that's just as much subject to, you know, the ADA and accommodation laws as a physical illness or physical problem. And so that is something that we've seen an explosion of recently, is people requiring or requesting reasonable accommodations due to anxiety or other mental health reasons.
Great. And then one last question. We're running out of time, but we had a question from Chris Jackal. He's an executive chef. Are we more or less likely to be liable for someone's illness if we're recording people's contact information? So if a business is engaging in contact tracing, will they be more liable or less liable should something happen?
I think if anything, if you're taking all the right safety precautions and you're able to say, you're able to demonstrate, here's our policy, right? Here's the information that we collect pre-shift for all employees, and here are the actions that we take. Let's say someone has been in contact with someone, we send them home, we require them to to quarantine, etc. I think if anything, you're more protected than anything else. Adam, you may want to add to that.
No, I mean, I agree with exactly what Katina said. I think that, and I fully admit that this is not necessarily my expertise, the area that I practice in, but from a general standpoint, in order to be held liable, generally you have to have done something that was, you know, negligent or careless, et cetera. And so if you can show that you're taking steps to actually be more responsible, generally speaking, that's a good place to be in terms of a defense standpoint.
Terrific. Thanks, everybody. Some really great questions posed, some incredible answers provided. I want to just thank everybody for tuning in and for our expert panel for joining us today and sharing what they know. I'd like to turn it over to Derek just for a few words before we say goodbye.
Thank you, Kate, and thank you again to the panel and all the participants and being here. Clearly by the questions and the content, this is sort of what's on everyone's mind. And the New York City Hospitality Group is made up of members across all categories of services that are asking sort of the burning questions of today. So we invite you to learn more about our group. I'll put it in the chat again. You can see who we are and what the future conversations are about. And a lot of these conversations are built and through feedback. So if there's anything that you know, you'd like for us to talk about and facilitate a conversation, we're here to listen. So thank you again for joining. The PowerPoint presentation will be on our hotline. And we hope to have another follow-up to this programming. So thank you for being here. We'll see you all soon, and have a great day.
Thank you, everyone.